One of the most ridiculous, unfair policies that the DA's office has in the state of California is that for all domestic violence cases, at the first court date, if they have filed charges, they are always going to ask for a criminal protective order barring the person who is accused from contacting the alleged victim. Now, maybe that would make sense if the alleged victim actually wanted this protection, but the thing is that the DA's office does not care. In this video, I'm going to be explaining the 5-step process to get rid of this criminal protective order. By the end of this video, you're going to have a much better understanding of how to get rid of this criminal protective order as soon as possible. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. So let's go through these 5 steps to get rid of a criminal protective order, or if you haven't been to court yet, at your first court date if charges are filed, to hopefully prevent a criminal protective order from happening. Number 1, take domestic violence classes, ideally court-approved domestic violence classes, especially if you have been to court and there is already a criminal protective order in place. This is the advice I give that everyone hates the most, that people argue with me about the most. And that is because it seems like if you take domestic violence classes, that you are guilty, that you need them, right? But that is actually not how the court system looks at this. And what these classes serve as it's really a few things. One of them is it is a CYA for prosecutors and judges. Look, the reason why prosecutors ask for criminal protective orders at the first court date, and the reason why, if the alleged victim isn't there, the judge will just grant it without even knowing if the alleged victim wants this or not, is because they want to protect their careers. They don't want you as the defendant, somebody who was arrested, they don't know you, they don't want you to go and do something crazy and all of a sudden it's on them because they didn't take certain action. If you take these domestic violence classes, it gives them a way to cover themselves, like, look, you were under the treatment of a professional. What more could they as a judge or a DA do? So start taking those classes early. If charges have already been filed against you, you probably want to do court-approved classes in your county. You can contact your attorney to make sure that you are going to the right classes. But you can also just look up your county and look up court-approved batterers intervention classes and do one of those. I do have a link in the description box for online classes if you haven't been to your first court date that you could do. Step number 2, get in front of the judge. Okay, so if you have been to court already and charges were filed against you, there's a criminal protective order already in place, then you're going to have a next court date that is maybe 30 to 60 days out. Now, 30 to 60 days is a really long time, especially if you have a family, you don't really have another place to stay, or your family can't really afford for you to pay for 2 places. So if that's the case, what you can do is have your attorney put the case on the court's calendar before the next court date. Now, different courthouses, different counties, different courtrooms have different procedures for this based on what they want. Some, it's okay for you to just show up at court one day, but for others, you do need to contact the court in advance. So your attorney can get an earlier court date. You do not have to necessarily wait until that next court date, especially if it's a long way out. Number 3, have the alleged victim go to the hearing. So the alleged victim needs to show up, needs to go in front of the judge, and needs to be part of this process. Step 4, talk to the DA. Okay, so you have your court date, you were at court, the alleged victim is there, your attorney is there, you have proof of classes if you had the opportunity to do some before, you've gone to these DV classes. Your attorney has to give the DA a chance to talk to the victim and see if this is really what they want. Now, usually the DA is going to brush the alleged victim off. I've actually had the DA leave the alleged victim in tears when I've done this before. But this is what you have to do. Otherwise, if you get in front of the judge and you've blindsided the DA, it is not going to look good for you. And the judge may say the alleged victim and the DA need to go outside, talk, and then you can come back in front of me. So this step is important, and sometimes if you have a good DA who is more interested in justice than just following his office policies, sometimes you can get them to agree or at least not object to getting rid of the protective order, or at least allowing contact between the alleged victim and the accused person. Number 5, go in front of the judge, and your attorney needs to facilitate this. So the attorney needs to turn into the judge proof of your domestic violence classes. If you weren't ordered to do these and you did them, you are ahead of most defendants in that courtroom, and you've already impressed the judge to some degree and given him that CYA, sort of that out, right? The attorney needs to inform the judge that we are asking for a modification or a removal of the protective order, the criminal protective order, and that the attorney has informed the DA. In my experience, it is better to just tell the judge that you've done all these things up front so that they can see that you know what's going on as an attorney and that you've checked all these boxes and they don't have to worry about it as much. The more that the judge worries about the case, the less likely that the judge is going to do what you want. And the attorney also needs to inform the judge that the victim wants to be heard. Now, when the alleged victim goes in front of the judge, they need to say 3 things to the judge. The first thing is that they want the protective order lifted and they want to be in contact with the accused person. The second thing is that they aren't afraid of the accused person. The third thing, and this one seems counterintuitive, but by statute, the judge needs to hear this, is that if anything were to happen, they would call 911. I know that makes it seem like they're expecting something to happen, but again, this is the judge checking that CYA box of, hey, the alleged victim came in front of me. They said that they would call 911. If they didn't and something happened, that's on them. So at that point, the judge is going to make a decision. Now, what if the judge says no and that the judge wants a protective order to stay in place? I, as an attorney, always try to set my client then up for success by asking the judge basically what they would want in order for the protective order to be lifted. If my client didn't get a chance to do any classes, what if they did classes? What if my client did counseling? Can we have an exception for marriage counseling, maybe online marriage counseling? Now, this makes it seem like, okay, this is serious. These people do want to be together. This isn't an abuser who has a victim under his thumb, which is what sometimes judges have the impression is true. This is a couple that really wants to work together and has a family and really wants to make it here. So it gives a good impression, but it also gives me a little promise from the judge. If the judge says, yes, I want your client to enroll in domestic violence classes, and fine, we can have an exception for marriage counseling. Okay, so now you at least have some contact through this online marriage counseling, but I want to see at least 5 sessions before the next court date. Okay, great. So now if I come to the next court date and I have those 5 sessions, I have whatever the judge asked me to do, now the judge is much more likely to do what I wanted and lift the protective order or at least allow peaceful contact. The other thing that I do is if there's a protective order in place and my client and the alleged victim want to be together, I'm not going to set the case out then for 30 days or 45 days. It doesn't make any sense. In that time, my client might be like sleeping on someone's couch, isn't there with his children. It can be a big problem. So I want to set it out for a much shorter time frame, usually as short as I can. I mean, not the next day because I need my clients to be able to do those classes and do the marriage counseling, but maybe 2 weeks instead of the usual 30 to 45 or even 60 days. Because yes, we can put it on calendar and we can try to come back sooner, but it's better if everyone expects, okay, we're just going to come back in 2 weeks and we're going to revisit this thing. And we're going to be persistent and keep revisiting it. And the judge is going to remember us in 2 weeks. And in 2 weeks, if my client has an impressive number of classes done, if he's doing his individual therapy or they're doing couples counseling and have a few sessions, then the judge is much more likely to feel like, you know what, I don't need to have this criminal protective order in place. I can lift it. And the accused person and the alleged victim can be together. I hope you found this video helpful. If you do have a domestic violence case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.